Welcome to Just Results Inside Criminal Defense.
Welcome back to Just Results Inside Criminal Defense with Mr. Gary Medlin. He is a board-certified criminal defense attorney and former prosecutor serving clients across the Dallas-Fort Worth area. Now, for more than 42 years, he's helped Texans protect their rights and their future when stakes are at their highest. I'm Evan Mack, and today we're talking about the biggest mistakes people make after being arrested and how a few quick decisions can make a major difference in how their case unfolds. Gary, welcome back, sir.
Happy to be here.
Let's talk about the biggest mistakes people make after being arrested. When you first meet someone who's just been arrested, what are the most common mistakes you see them already making right out the gate?
You know, the first mistake is talking. We have the right to remain silent, but most of our clients didn't have the ability at the time of the arrest. And sometimes that happens before they're arrested. They've been detained. The officer is investigating them for some person, for some reason. And, they ask questions and the person answers the questions. That's the first mistake that we see people make. Then after a person's been arrested, they should be informed of their right to remain silent, their right to have an attorney, and the right to stop the interview at any time. But most of the time, even whether they've been advised of that right or not, our clients will answer questions, and they almost always make their case worse by answering any questions. Even when a person is innocent, by answering questions, they can make their situation worse. For instance, sometimes when a person, even when they're innocent and they answer questions, they clear up issues that the government might or the prosecutor might have to prove otherwise and might have difficulty with. Or sometimes, even when they're innocent, their answers may corroborate or combine with the evidence that the government has to make that case stronger against them. Or sometimes, even when they're innocent and they answer questions, they give the police or the prosecutor just enough to go ahead and prosecute them when they wouldn't have had enough otherwise. So the first mistake is answering questions. Even when you're innocent, don't answer questions. Most people aren't going to be very persuasive or help their situation by answering questions even when they're innocent. But most people have this idea that, I can talk my way out of this, or I'm close to home, or I didn't do this, so I'm going to tell them what that other person did, or I'm going to talk my way out of this. And usually nobody can do that. Usually everybody makes that situation worse by answering questions. So the first thing the person should do is tell the officer, I invoke my right to remain silent. I'm not answering any questions. And that's not going to be something that can be used against the client. That's not going to be something that would be evidence in court against them. That's not going to be something that causes the person to be arrested when they wouldn't have been arrested otherwise. And, the cops will try to trick people with this situation all the time. They'll say, well, if you're not going to answer my questions, then I'm just going to have to arrest you. Or, we think this was an okay situation, and we just need to get your side of the story so we can close this out. And they'll try to trick you into answering questions, and so you don't lawyer up and make this worse for you. But it's always a mistake to answer questions. It's never going to make your situation worse. So don't answer the questions. Invoke your right to remain silent. Say, I'm not talking without an attorney. That's what the first mistake that people make in their cases. The second mistake would be, once they've been arrested, not taking it seriously enough or not getting the proper representation. And this is really sad, and I really can't understand why it happens, but sometimes people will think that, defense attorneys, criminal representation, it's all the same. So I'll just talk to a few and see who's the cheapest and just hire them. And that's almost always a mistake. And let me tell you, there's a dirty secret in criminal defense, and that is most of the attorneys and firms out there don't plan on fighting for their client. They just want to get the client to take the first offer that the prosecutor makes. And I've even heard defense attorneys say this, and it shocks me. I've heard them say, well, they're all guilty, so I'm just going to plead them guilty. I'm just going to take whatever the prosecutor offers. And that's just shocking to hear anybody who has been through law school, has passed the bar exam, and holds themselves out as the defense attorney to say that, well, they're all guilty. or I'm just going to plead them all guilty. And there's a lot of what we call dump truck lawyers out there. Just bleed them and plead them lawyers. They just want to get a little money from the client and then make them plead guilty to the first thing the prosecutor offers. And that's not good representation, and that's not a good way to choose an attorney by price. So, the first thing to realize that, if the attorney quotes somebody what they think is a pretty low fee, that's a dead giveaway right there that they don't plan on fighting the case. A lot of attorneys have this idea that, I'm not getting enough of a fee, so I'm not going to spend any time working on this case. I'm just going to try to get rid of this case as quickly as possible, as easily as possible. I'm not going to spend the time investigating the case that it needs. So that's the second mistake people make, and not getting the right representation, not getting good representation, making their decision based on price. So, we say good representation is not cheap, and cheap representation is not good. So they need to get really quality, good representation, and they need to realize that it may cost a lot. But that's because good representation is going to cost a lot, because the attorneys out there who plan on fighting, who plan on really doing the best they can for the client, getting a just result, getting justice for that client, they're going to have to spend some time on that. And so it's going to take a fee that allows them to spend the time on it. So that's the second mistake that people make. Then the third mistake that people make is not really understanding the case against them, not having the good representation that helps them understand the case against them, understanding the facts, understanding the law, understanding how those things are going to combine to either make the state able to prove a case against them, or possibly not be able to prove the case against them. So understanding what their, how good their case is to fight. To understand if they have a way to hold out for a dismissal or a reduction of the charge, or go through a trial and make the state prove it beyond a reasonable doubt to a unanimous jury of 12 or 6 people if they can. And if not, then that person's found not guilty. So looking at the case and understanding what the risks are, what the chances of success are, and which way they should go. So that'd be another mistake that people make, not thoroughly understanding that. Another mistake people make is we talked about how, don't answer questions. Don't, when you're detained by the police or you're arrested by the police, don't answer questions. Invoke your right to remain silent. Well, once a person's going through a trial, everyone has the right to not be compelled to be a witness in their case. But people have the right to testify if they want to. And a lot of people make the mistake of testifying, if you got a chance of winning without testifying, don't do it. And because when you testify, then you're going to be subject to cross-examination, and it can be difficult for anyone who's accused of a crime to make a good witness in their case and to survive the cross-examination without making a mistake or making some admission or answering a question in a way that it gets used against them. And sometimes that changes the dynamics of the trial to the jury looking at whether or not the state has actually proved it beyond a reasonable doubt to them and really convince them, to then changing it to whether they like the defendant or not, like the citizen accused. And then if there's something about it they don't like the client, then they find them guilty just because they didn't like them more than whether or not the state had proved it beyond a reasonable doubt. So that's another mistake that people make.
So Gary, social media is interesting because it hasn't always been around, but now it's kind of becoming issues in criminal cases or cases in general. Well, what kind of online activity can come back and haunt somebody because they just can't stay off social media?
That's a really good topic to talk about, and it's amazing. That's something we talk to our clients about quite often, is stay off social media, because the prosecutors are going to be looking at it, and they're going to be looking at anything they might be able to use, any type of admissions, any type of things that just don't look good. We got a client charged with DWI, and then there's some photos on their social media of them, drinking from a beer pong, or doing some other wild, crazy party activities, or holding weapons, or so sometimes the pictures just get used against our clients. So they got to be careful about what's on their social media, and also just stay off and don't talk about what happened. Don't make any admissions. Don't talk about what they were doing or what really happened, or they just really have to stay off the media because it's going to be looked at, and also sometimes if it's a crime where there is a person who's alleged to be a victim, a complaining witness, don't have any contact with that person, so it can't be used as or interpreted as intimidation or witness tampering or anything like that. But yeah, they got to be careful about social media. Yes.
So some people think cooperating means explaining everything right away. So they kind of get trapped into that right to remain silent thing because they're not trying to be rude. They're not trying to be disrespectful, non-compliant. But what's the right balance between being respectful and also protecting that right to remain silent?
That's a great question because, that's one of the problems for us is that, we're all raised to be respectful and to be cooperative and to respect authority. And the cops, they'll use that against everybody, because they know that most people, if you ask them a question, they're going to answer.
Yeah.
And the cops will use the power of their authority figure against people. So, don't worry about being respectful. You don't need to be respectful of the police when you're the subject of an investigation or when the police are looking at charging you with a crime. There's no need for you to be respectful of the police in that situation. They're not being respectful of you, I guarantee you. They're not being respectful of the client, and they're trying to trample on people's rights. So, you don't need to be rude. You don't need to be combative or anything. You need to be cooperative in the sense that if the police order you to step out of the car, if they order you to submit to arrest, you do so without struggle, without resisting in any way, but not by answering questions. That's not the cooperation that you have to give. So, when the police start to talk to a person or detain a person, one of the first things you can do is you can say, am I being detained? And if I'm not being detained, am I free to go? Okay.
Okay.
And if the officers say, well, they don't really have enough to arrest a person yet. They're just fishing, or they're just trying to develop a case, but they don't have enough. You ask them that question: am I free? Am I being detained? And if not, am I free to go? They have to tell you, yeah, you're free to go. Okay. They tell you, no, you're being detained, then you just don't answer any questions at that point. You don't cooperate with that. Okay, they tell you to turn around and put your hands behind your back because they're going to arrest you. Then you cooperate. Don't resist. Don't struggle or in any way. Don't take off on foot. And evade. Go ahead and submit to that. But that's all you have to do. You don't have to answer any questions whatsoever. And in Texas and in the United States, if you're just walking in public and the police start to talk to you and they say, I want to see some ID. You don't have to give them any ID. You don't have to have any ID. You don't have to have a license on you. We still don't have a situation where papers, please is actually the law. Now there's some exceptions if you're within a certain distance of the international border, but otherwise, you don't have to have any type of identification, passport, or anything else on you. Now, you do have to identify yourself if you're a witness or if you're being detained. But all you have to do in that situation is give your name and your date of birth and your address. Now, if you're driving a vehicle, of course, the law requires you to have a driver's license to drive a vehicle. So in that situation, you do have to have an ID, but otherwise, no.
So Gary, let's segue to court. What happens if someone misses a court date, fails to follow bond conditions early in the process? How bad can things get?
That's not a good thing. So because it's about your freedom. So you don't show up for a court date, then the judge issues a warrant. They declare a bond insufficient. They forfeit a bond. But either way, they issue a warrant for someone not appearing for court. Okay, so that's a bad situation. Then you're picked up and you're in jail, and then it's more difficult to get back out because you're going to have an attorney. The attorney's going to have to appear before the judge, and then because you didn't appear, then that kind of makes the judge suspicious about letting you out. Are you going to appear the next time you're supposed to appear? So then, it's likely that the bond is going to be double whatever it was before. So that's a bad situation. Also, whenever a person is on bond, there may be conditions of that bond. Quite often there's conditions especially in a DWI case, of having an interlock device on a car, like a blow device. device. So you have to blow into the interlock to start the car. There may be conditions of submitting to urine testing periodically, twice a month or once a month, and staying clean. And then if you submit a urine sample that's dirty for a controlled substance or marijuana or something, then your bond gets forfeited or declared insufficient, and again a warrant's issued for your arrest. So those are situations that you really have to be careful of, because the judge has the power to make conditions of bond for a person who's on bond, and if a person violates those conditions or doesn't show up for court, then a person's going to get arrested again.
How can a delay in hiring an attorney change the direction of a person's case?
That's a really bad thing to delay. You need to get you need to get good representation, and you need to get it as soon as possible, because there's things that good representation can take advantage of early on that may be lost with the passage of time. For instance, in felony cases, sometimes it's important to address the case at the grand jury level. So typically in Tarrant County and other places, any felony is going to be taken before the grand jury, sometimes within 90 days of the arrest. So nobody in Texas can be required to stand trial for a felony unless they have been indicted by a grand jury. So a grand jury doesn't decide if somebody's guilty or not. They just decide if there's enough evidence that the person should stand trial. Some attorneys will tell you that the grand jury decides if there's probable cause. Well, that's not really true. There's not a certain limit or legal standard that the grand jury has to decide. They just decide, is there enough evidence this person should stand trial? But they can also decide that there's not enough evidence. And so they can decline to indict. So it's if they indict, then they return a true bill of indictment. If they decline to indict, then they no bill the situation. So that's like a dismissal when they decline to indict, and the case is over, and basically it's like a dismissal, and that's it. So that's a good result. So sometimes we can address the felony case at the grand jury level and share evidence or share testimony with the grand jury that shows the grand jury that they should not indict the case. But again, that's quite often happens within 90 days of the arrest. So that's an opportunity that may be lost without getting good representation and getting good representation early in the situation. But also witnesses may become available, or evidence may change, or the status of a scene where a person was arrested or where something happened may change. So it may be that things like that need to be investigated or photographed or documented early on. So that's another reason why I think should be done early. But otherwise, you need good representation, so that you start doing it early and take advantage of the opportunities that happen early on. Also, in dealing with the prosecutor early on, it may be that there are situations that can be done that you may lose the opportunity for later. The better. It's always better to get the good representation as early as possible.
You've seen a lot of first-time defendants. What separates people who recover quickly from those people who kind of make their situation worse?
So I see a lot of people who actually take the situation seriously. They make sure that they secure good representation, attorneys who are really going to fight for them and try to get the best possible just result for them. Those persons have the best chance of recovering quickly, of restoring their good name and their clean record. But some people make the mistake of hiring counsel based on price, getting that cheap representation, and they lose the opportunity to get the good result in their case, or they make some bad choices along the way, or they take a plea bargain they shouldn't have taken, and then they have a permanent criminal record that they can't fix. So the good representation, quality representation from attorneys who are actually going to fight. That's the most important decision and the biggest difference between the people who recover quickly and those who don't.
From your experience as both a prosecutor and a defense lawyer, what mistakes do you wish every person understood before they even face a single charge?
I wish people understood the power of the government, the prosecution. The district attorney, say, in a crime charged in state district court in Tarrant County, the government has such incredible power and incredible resources to bring to bear in impression of the citizen accused that it's just awesome. So you need to do whatever can be done to try to level the playing field. You're never going to be able to get a level playing field with the government, but you're going to be able to do the best you can if you have the good representation from attorneys who actually fight and actually know how to fight and actually win cases for their clients, and know how to level the playing field, know how to use the power subpoena, the way to investigate, to use witnesses, experts if possible, to use other tools that we have in our arsenal of defense tools to help our clients. Sometimes using other experts in the investigation, and sometimes polygraph or evaluations or other expert testimony can be used to help level the playing field. It's just not a level playing field at all. So the only chance the little guy has of getting a close to level playing field is through quality, good representation. And that's not usually going to be cheap.
And Gary, finally, what's your best advice for anyone who feels panicked right now and doesn't know what to do next after an arrest?
The best advice is getting good quality representation as soon as possible. Getting the attorneys who are really going to fight and know how to win.
Good stuff. Gary, appreciate the time.
Okay. Pleasure.
Thank you so much for joining us. That's it for today's episode of Just Results Inside Criminal Defense. This podcast is for informational purposes only and does not constitute legal advice. To learn more about Gary Medlin and the Medlin Law Firm, visit medlinfirm.com. And don't forget to like, subscribe, leave a review if you found this information helpful. Thank you so much, and we will see you next time.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.